Today we'll be talking about passing off. Passing off is another way of protecting business reputation. Others include the protection afforded by trademarks, to some extent, the protections against misleading and deceptive conduct, and the protection afforded by the tort of injurious falsehood. But the one we'll be focusing on today is the tort of passing off. At its core, passing off is about the cause of action that arises when one trader pretends or misleads to consumers that they are linked to or they have some association with another trader with established reputation. So there are three elements to passing off. The first is that the trader has a reputation in the geographical area. The second is that there has been some sort of misrepresentation about association with the trader. And the third is that the trader has suffered some level of damage or harm as a result of that misrepresentation. It's not a tort of unfair competition or a tort against all sorts of business copying. It is fundamentally dependent upon the misrepresentation associated with the reputation of the plaintiff. The first element is that the plaintiff have some reputation in the jurisdiction, some distinctive character that people would recognize the goods or services would emanate from the plaintiff. This is also open to foreign traders, but they must be able to show a reputation in the jurisdiction. So, for example, in the McCain and Conagra case, when McCain took the name Healthy Choice, which had been used in the US, and imitated the style and getup of the US traders' merchandise, that wasn't enough to found an action of passing off because Conagra had not established a reputation in Australia. They don't have to have their trading or headquarters or even a geographic base here, but they need to have some reputation established within Australia. Alternatively, it might also be established on the basis that prospective clients, consumers, might assume that the goods have some sort of distinctive characteristic that is distinctive of the plaintiff's goods or services. So, for example, in the Spanish champagne case, the word champagne wasn't distinctive of any particular merchant. 150 merchants were able to use the term champagne. But the term champagne connoted some particular characteristics of quality about those particular merchants. They had sufficient reputation in that name to establish a founding of an action for passing off. The second element requires that there has been a misrepresentation. And this can be, for example, that the defendant represented that there was some form of association between the defendant and the plaintiff, or that the goods or services came from, originated or emanated from the plaintiff as opposed to the defendant, or that the plaintiff and defendant's goods or services originate from the same source or share some distinctive characteristics or qualities, or that the defendant's product is actually the plaintiff's product. So, for example, in the Solo case, when Pub Squash marketed their soft drink, their lemon-flavoured soft drink, in the same way as Solo, embodying themes of manliness and outdoors activities and nostalgia for the good old days, Pub Squash evoked the same imagery as the Schweppes advertisements. They sold their packages in familiar yellow cans and bottles, and they clearly bore some resemblance to Cadbury Schweppes' Solo product. But that wasn't enough. The court found that although the advertising was similar, there was no misrepresentation. Pub Squash wasn't trying to pass off its products as being the same or connected in any way with Cadbury Schweppes' Solo brand of products. Passing off does not prevent copying. It only prevents misrepresentation about association. The court, in the end, found that there was no actual confusion amongst consumers, that even if they were initially confused about the origin of the goods because of the similar advertising, that error was quickly found out. Another example is the Philips and Remington case. When Philips introduced its triple-headed razor, Remington copied that product design. Philips wanted to prevent Remington from imitating its products, but it couldn't do this under the tort of passing off. The court was very clear on this. Passing off does not provide a monopoly in products. Patent law might be an appropriate source of that monopoly, but patent law comes with its own restrictions and comes with a very limited time period. Passing off and trademark protection are unlimited. Allowing Philips to extend its monopoly via trademark infringement or passing off would unduly restrict competition in the market for, in this case, shavers. Remington was held not to have misled consumers into thinking there was any association between the two companies or the two brands or the two products. In this case, Remington absolutely copied the design, the look, and the functionality of the product, but those are not things that are appropriately protected by the tort of passing off. The courts refused to use passing off or trademark infringement to grant Philips a monopoly in a three-headed electric shaver. On the other hand, we have cases like the Duff beer case, where the court found that consumers might actually be misled into thinking that this particular beer brewed by a South Australian company was associated with The Simpsons. On the other hand, when Mars tried to prevent people from copying its Maltesers products, it failed to establish an action under the tort of passing off. The court in that case held that Mars had become a victim of its own popularity, and that it couldn't prevent people from creating other spherical-shaped malt chocolates in the familiar red and black or brown chocolatey colours that had become associated with Maltesers. The tort of passing off won't grant a monopoly right to prevent people from creating similar products where there is no association claimed between the derivative or copied product and the original trader. Passing off can also be used for character merchandising purposes. It provides, at least for famous people, an ability to prevent others from using their likeness. The basis of this protection is that consumers might be misled into thinking that the celebrity or the other person with reputation had endorsed the production of the goods or services. This leads to the interesting position that while in Australia we don't have a right of publicity, celebrities do have protections under passing off that are not afforded to the ordinary person. So this was enough, for example, to allow Paul Hogan to enjoin the use of imagery that evoked his Crocodile Dundee character to sell souvenirs and Australiana. Hogan was granted the injunction because there was a clear association between the souvenirs shop's koala advertisement, which held a knife, a sleeveless shirt, and a hat, and Paul Hogan's Crocodile Dundee character. Hogan was again successful in obtaining an injunction against Crosby Shoes, who had created a parody of the "Call That a Knife" scene from Crocodile Dundee with their particular brand of shoes. The court, in what some people think is a bit of a questionable judgment, found that there was some suggestion that consumers might think that there was an association, that Hogan had endorsed the shoe company. If you remember Telstra's Go-Go Mobile case, after Telstra failed on its claim of copyright infringement, it alleged that Royal Sun Insurance had copied and misrepresented its association with the original Telstra Go-Go Mobile advertisements and characters. After the copyright claim failed, Telstra was actually successful in one of its passing off claims. The reputation associated with Mr. Dysart and his problem-solving attitude had become distinctive to an extent of Telstra or Telecom at the time. When Shannon's used that character, played by the same actor, in his problem-solving context, they were found to have evoked some association with Telstra's original advertisements and reputation in that. Importantly, when Shannon just evoked the imagery of the original without actually misrepresenting some association, they were not liable for passing off in those other commercials. The third element is that of damage. The plaintiff must have suffered some harm as a result of the misleading behaviour. This is actually usually pretty easy to show, as the plaintiff is able to allege that they have lost the ability to expand their markets or lost some sort of distinctiveness associated with their brand and the control over. So, for example, when an Israeli company was marketing garden tools under the brand Lego, the Lego company was able to show harm even though it couldn't show any intention to extend into the gardening market. The relevant harm in that case was the loss of ability to control Lego's goodwill or business reputation. So it's relatively easy for a trader to show this third element of harm. The remedies for passing off, most commonly an injunction. The plaintiff may elect between damages and an account of profits. And the plaintiff may request delivery up of any goods that are found to have borne some sort of association with the plaintiff's reputation. It's important to distinguish between passing off and misleading and deceptive conduct. Even though they are often used in very similar circumstances, they do serve different functions, and that has differences in consequences at the margins. Passing off protects reputation. It protects the legitimate business interests of traders. Misleading and deceptive conduct, by contrast, protects consumers. It will protect consumers from being misled or deceived, but doesn't protect the reputation the traders have established per se. So passing off, in conclusion, operates in very similar circumstances as trademark infringement. But in most cases, trademark infringement will be easier to prove. Where the trader doesn't have a registered trademark, however, passing off provides an important remedy. So if the trader has lost their trademark, if they never registered their trademark, or if they forgot to renew their trademark, in that case, the plaintiff will often want to fall back on a claim of passing off. So as a reminder, the three core elements, or the classical trinity of passing off, are 1, the plaintiff has a reputation. 2, there has been a misrepresentation by the defendant about some association with the plaintiff. And 3, the plaintiff has suffered damage as a result of that misrepresentation.